Hi, I'm Steve Carlson. This is the second of two videos addressed to the U.S. Senate as part of the record of an election contest against Al Franken and the DFL in Minnesota, where the state has suspended democracy by destroying the right to vote, destroying the nation's oldest and largest independent third party, which has long been a major political party under Minnesota law, but which has been attacked by a conspiracy of the DFL and Republicans abusing their power, refusing to follow the U.S. Constitution, Article 1, Sections 4 and 5, in order to destroy that voice of the independent voters, who this year actually outnumber the Democrats and Republicans combined, and pose a great threat to the two-party establishments. For instance, both Bernie Sanders and Donald Trump are actually independents who are beating the Democrats and Republicans in the 2016 presidential race. And so I'm going to start with the role of the courts and the role of this U.S. Senate in protecting the vote. Chief Justice John Roberts, in a recent public appearance, addressed how he perceives the role of the courts, in this case of Al Franken, the United States Supreme Court, and the Minnesota Supreme Court. And the panel is set up to represent the whole state. Hennepin, Ramsey, and Anoka counties judges were picked for a three-judge panel. These same issues were also addressed in a book discussing the U.S. Supreme Court in Bush v. Gore by Martin Garbus, when he thought that there would be, at the time he wrote the book, a conservative court for 25 years. And so the book is called The Next 25 Years, published in 2007. That book reviewed how more has been learned of what happened in Bush v. Gore because of the memos of law clerks and other insiders have been made available, showing the battles raging inside the Supreme Court at that time in Bush v. Gore. What the Supreme Court has wrongfully done in this case is to help the courts interfere in this contest to aid Al Franken and to crush the IP. I am asking the Senate to obtain the memos on this wrongful Supreme Court action, refusing to instruct Governor Dayton to withdraw the unlawful certificate and to recertify with a contest with the discovery contemplated in Minnesota Statutes 209.12. And I'm asking you to authorize discovery and hearings on these matters to restore a Republican form of government in Minnesota and protect the right to vote. Now here's Carlson versus Franken vis-a-vis Bush v. Gore vis-a-vis Coleman versus Franken. In handing down Bush v. Gore, the majority explained none are more conscious of the vital limits on judicial authority than are the members of this court, and none stand more in admiration of the Constitution's design to leave the selection of the president to the people through their legislatures and to the political sphere. When contending parties invoke the process of the courts, however, it becomes our unsought responsibility to resolve the federal and constitutional issues the judicial system has been forced to confront, unquote. That's from Bush v. Gore. The citation is 531 U.S. 98 from 2000, or something like that. The per curiam is wrong. I am more conscious of the vital limits of judicial authority because the Minnesota courts and the Supreme Court have intervened to help Al Franken and the DFL in this case, and to help both major parties crush the IP by cutting off all constitutional rights, allowing nothing in the press but attacks on my record and positions which were all patently false, but allowing no debate on those issues, but also no public knowledge of this tremendous battle about voting rights going on behind the scenes. It was available on my YouTube account and website, so the press, courts, and politicians knew about it, but would not allow these matters to be discussed. In one instance, Star Tribune columnist Lori Sturtevant did write that the Tea Party could never take over the DFL because they used proportional representation. But that is the only instance I know of, and it didn't talk about the IP. I run as a Tea Party candidate. Now there are two differences between Bush v. Gore and Carlson versus Franken that I want to note. First, that case involved a presidential election, while this case is about a congressional election involving the manner of issuing an election certificate to Al Franken and unconstitutional practices by state officials. the two major parties, Democrats and Republicans, and courts in Minnesota in attempting to suppress freedom of expression and association and invalidating the vote of Minnesota voters based on status, gender, race, sexual orientation, and other characteristics in a transparent attempt to alter the composition of the electorate and the resulting votes taken in the nomination process. The second difference is that Bush v. Gore, like Coleman versus Franken, dealt with a recount, a mandatory recount, which is a contest in a presidential election. Ultimately, it might have been thrown into both houses of Congress. But Coleman's case also dealt with issues of the Minnesota courts. The canvassing board, headed by Mark Ritchie, had found a box of votes in a car and added those in and declared Franken the winner. Election certificate. Like this case, the problem began when Al Franken applied for an election certificate as soon as he got ahead, not wanting to wait for the pending contest to be properly adjudicated. I cite a Wikipedia account of this part of the case, the certificate and the contest. After the canvassing board finished the recount, the next step was for the state to issue an official certificate of election. State law requires a 7-day delay from the canvassing board's final report until the certificate can be issued and signed by Ritchie and Minnesota Governor Tim Pawlenty. He is a Republican. Dayton's a Democrat. Furthermore, state law states that a certificate cannot be issued if an election contest is pending. This is the state law that Mark Dayton has signed the repeal of. On January 12, 2009, Franken sent a letter to Ritchie and Pawlenty requesting an election certificate. Both declined, citing the unresolved election contest by Coleman. Later that day, Franken filed suit in federal court to force the state to issue a certificate, claiming that federal law relating to Senate elections superseded state law. The next day, his campaign asked the Minnesota Supreme Court to require Pawlenty and Ritchie to issue the certificate, and the court held a hearing on the suit on February 5, 2009. Texas Senator John Cornyn said that GOP senators were prepared to filibuster the seating of the canvassing board's declared winner until a signed election certificate was available, as provided under Minnesota law. On January 21, 2009, the day after the inauguration of the Democratic President Barack Obama, Senate Majority Leader Harry Reid said that Senate Democrats are going to try to seat Al Franken, at least provisionally, until the challenge is resolved. Reid also said that there was not a question in anyone's mind that there's been any fraud or wrongdoing in this election. Well, that distinguishes it from the 2014 election, in which there is a great doubt that fraud and wrongdoing were not involved. Senate Republican leaders countered this by insisting that Franken respect Minnesota laws and allow the completion of the legal review. The election contest. Coleman filed a contest of the election results in the Ramsey County District Court on January 6, 2009. In it, he alleged ballot counting irregularities, which, if corrected, would result in his winning the election. Among other issues, he alleged that there were double-counted duplicate ballots, 654 valid absentee votes rejected as invalid by county election officials, and problems in dealing with the lost ballots in a Minneapolis precinct. Under Minnesota law, the Chief Justice of the State Supreme Court appoints a 3-judge panel to hear an election contest. Because Chief Justice Magnuson had served on the state canvassing board, he recused himself, passing the task to Alan Page, the senior justice on the court. Page chose Judge Elizabeth A. Hayden of Stearns County, wherever that is, who was first appointed by DFL Governor Rudy Perpich to preside over the contest. I know it's in Duluth, but it's not one of the big voting areas. I don't know why Page selected that. Assistant Chief Judge Kurt J. Marbin of Pennington County, appointed by the Independence Party Governor Jesse Ventura, and Assistant Chief Judge Denise D. Riley of Hennepin County, appointed by Republican Governor Arnie Carlson, were also appointed. And so this is a funny panel that Page selected, but in my case, they chose Hennepin, Ramsey, and Anoka, the largest ones. Now, on January 12, 2009, Franken filed a motion to dismiss Coleman's contest, claiming it was, quote, an imprecise and scattershot pleading, unquote. And probably who filed it was David Lillyhaug, who's now on the Supreme Court, that blocked the Senate from hearing mine. That was his attorney. Now, Franken filed a motion to dismiss scattershot and imprecise pleading. He argued that even if the contest were to proceed, the three-judge panel should be limited to determining who should be awarded the already certified ballots and to a simple mathematical recount to ensure the accuracy of the canvassing board's count, while no additional ballots should be reviewed. On January 22nd, Franken's attorneys also argued that the case should not go to trial because the U.S. Senate itself, rather than the court system, has the power under the U.S. Constitution to judge the election of its own members. Somehow he seems to have forgotten that in 6 years. Franken's motion to dismiss was denied by the panel January 23rd. On January 19, 2009, Coleman attorney Fritz Knock requested that the court open and review all rejected absentee ballots, totaling roughly 12,000, because some of them, he contended, were improperly rejected, just like this box they found in Hennepin County. Coleman's attorneys also proposed a multiple-phase trial that would not start until February 2nd, in which the first phase would focus on rejected absentee ballots. The panel denied these requests January 23rd. The trial began January 26th. Coleman's legal team ran into trouble on the first day when the judges refused to enter into evidence copies of the envelopes from allegedly wrongly rejected absentee ballots. Coleman's team had marked on some of their other copies of the envelopes, so the panel ruled that Coleman's attorney would need to subpoena the original absentee ballot envelopes from the counties. So otherwise the copies would have been accepted, and I guess this is the panel. Now on February 3rd, the judges agreed to consider 4,797 rejected absentee ballots. This was fewer than the number requested by Coleman, but greater than Franken requested. These ballots fall into two categories: those where voters appear to have met all legal requirements, and I'm going to skip over some of this. Suffice it to say that this went on till about June. And my point, and I do want to add that Dean Barkley, the 2008 U.S. Senate nominee of my party, the Independence Party, was allowed in debates and had served in the Senate by appointment and won about 15% of the vote. And so this is a very great departure of what was allowed this year when there was a concerted effort to stamp out the IP. And so this is why I want this party to address the requirement of the states to follow the laws and not to take away the right to vote and destroy small parties. There was then an appeal to the Minnesota Supreme Court on April 20th. Coleman filed a notice of appeal. Some of the Democrats and political commentators asserted Coleman no longer had a serious chance of prevailing, and that he continued to file appeals for the sole purpose of delaying the seating of the 60th member of the Democratic caucus in the U.S. Senate, after Pennsylvania Senator Arlen Specter changed his party affiliation from Republican to Democrat April 28th. 60 senators would bring the Democrats to a level where they would not need any Republican votes to overcome a Republican filibuster in the Senate for the balance of the Senate term, assuming a straight party line vote. People like Bernie Sanders, Angus King, or independent senators who caucus with the Democrats. Norm Coleman disputed these allegations, but about 60% of Minnesotans at that point wanted him to withdraw. And on June 30th, 2009, now here Mark Dayton sends it December 19th, before the date, but according to the procedures of the Minnesota law, it took till June 30th before this great national spectacle could be settled by Alan Page and the people that he picked out. Now, the issues in this case. This recounting of the Franken 2009 case shows that the two major national parties have reason to do away with the IP and the rights of independent voters. That's because of the role Dean Barkley played. And also that Al Franken was fully aware, without a doubt, that during the pendency of a contest, Minnesota election law required that he comply with the procedures of the pending contest. And yet, with the DFL governor this time, and with a conflict involving Mark Ritchie about the wrongful withholding of public information, which he himself used to raise funds for his party, Dayton Ritchie ignored the contest provision, and Franken the cooperation of the Minnesota Supreme Court and its panel to violate the Constitution, and really with Franken and that cooperation and election laws to rush Franken to Washington. But there were serious issues which this body needs to deal with and would already have received had Franken and the DFL and the Democrats followed Minnesota law. And these issues are not in the least diminished because they do not involve a mandatory recount. To begin with, in Senate elections in Minnesota, there is a state law keeping voters away from voting at precinct caucuses if they do not agree to themselves or others being forced out by voting. If they disagree, they are barred from participating, even as a candidate. I could not run as a Democrat while opposing this illegal affirmative action requirement in the party itself. The right of freedom of association extends to my right as a candidate and nominee to associate with these voters who are barred from participation because they believe in true democracy. That means unrestrained voting. My challenge to this practice in turn led in 2012 to depriving me of the means to get my message, including my message on voting rights, out to the voters. And my attempts to access Congress to resolve this by following Minnesota election law were blocked. Then when I apparently astounded Minnesota by beating the endorsed candidate and 3 others in a statewide primary, Franken and the others got deadly serious. Franken associates like NPR spread around a rumor that I thought it was a blessing or public service that Trayvon Martin was killed, that I defended Todd Aiken's remarks on no abortion exception being justified because of legitimate rape, and took my comments that these gender and race quotas reducing the possible participation of white males as delegates was in fact a war on white men. But I was not allowed to debate. I could not challenge these voter quota practices in debates either. As I found out, the duopoly would claim the right to exclude me from all debates. I had polled at 13% statewide in a Gravis marketing poll against Franken and McFadden, and this should have justified my participation in debates by any reasonable standard. Further, as I took these matters to the Minnesota Supreme Court, she indicated none would be reviewed. As time for the last debate was running out, my emergency motion, which for some reason I directed to Stephen Breyer, I had started to read Active Liberty and supposed this would at least include free and fair elections, seemed to reach him just in time but was not acted on. My testimony has been and is that the forced quotas in the Minnesota DFL discouraged me from seeking the support of that party, but going to the Independence Party. That does not end my standing to challenge these serious violations of the Constitution. Duties of the Senate. I have reason to believe that these divisive quotas add to the divisive polarization of American politics. I do not understand why Republicans have done nothing, but it could be that the Minnesota Republicans wanted to get rid of competition. Many of the IP were Republicans anyway and were excommunicated after the 2010 elections. Chief Justice Roberts, in remarks soon after the Supreme Court finally denied my rehearing in my case against Al Franken and the corrupt practices of his party, addressed the law school. Partisan fights over Supreme Court nominations hurt the court's image, Chief Justice Roberts says, is the Washington Post headline. Robert Barnes' account had this quote: "If we uphold a particular political decision, that remains the decision of the political branches. and the fact that it may lead to criticism of us is often a mistake, he said. We do have to be above or apart from the criticism because we, of course, make unpopular decisions, very unpopular decisions, unquote. Because this case is about atomic individual voters and small and third parties, it's hard to paint this as a matter of very unpopular decisions. However, the answer to these great troubles is democracy, not quotas and social engineering, and the Republican form of government, and the protections of the 15th and 19th Amendments, and not voter reparations. The practices of voter quotas also violate the 14th Amendment, as in Smith versus Allwright infra. And with these democratic practices, that Republican form of government is disappearing. Diversity is being reduced, and reduced to a mere caricature of democracy. In a broad deal to keep minorities happy by giving them broader coalitions of other minorities using the Democratic Party as a kind of battering ram. In my opinion, we have seen the result of this. This body has the right and duty to keep free and fair elections in Minnesota and all the states. Section 4 of Article 1 of the Constitution adopts the state qualification as the federal qualification for the voter. But his right to vote is based upon the Constitution and not upon the state law. And Congress has the constitutional power to pass laws for the free, pure, and safe exercise of this right. That's citing from Ex parte Yarborough. The 15th Amendment of the Constitution, by its limitation on the power of the states in the exercise of their right to prescribe the qualifications of voters in their own elections, and by its limitation of the power of the United States over that subject, clearly shows that the right of suffrage was considered to be of supreme importance to the national government and was not intended to be left within the exclusive control of the states, identical. In Carlson versus Franken, both the 15th Amendment and 19th Amendment are applicable to prevent abridgment or denial of the right to vote to any eligible voter on the basis of race or sex. This applies to white males, etc., and some members of any class are going to be deprived of this right when their vote is taken away from them and given to another because of the idea that some kind of reparations in voting are in order, even if they violate the U.S. Constitution. The very device that is at work in the practices challenged here, which are done with the force and under the color of law, is to abridge the right to vote of some so that others may instead be represented because of their gender, their race, or sexual practices. The DNC new rules. In the delegate selection documents for the 2016 Democratic National Convention, proportional representation or gender division is required of all 50 states. They include the requirements, procedures providing for equal division in each state's convention delegation, meaning requiring a gender division in the composition of voting delegates, such that if a man wishes to vote, but there are too many men already voting, then the voting right will be taken away from him and reserved for a woman or some other group status. I don't know if it applies to them. Also 6, affirmative action plans and inclusion programs in detail, including affirmative action and inclusion obligations of presidential candidates, actually obligates every candidate to submit to such a plan in order to be considered for the nominee selection. In the first instance, voters who disagree with this engineering by status will not have a candidate because every candidate must submit. I do not contend the following elements of the DNC plan offend the Constitution. 1. All public meetings at all levels of the Democratic Party in each state should be open to all members of the Democratic Party, regardless of race, sex, age, color, creed, national origin, religion, ethnic identity, sexual orientation, gender identity, economic status, or physical disability, herein collectively referred to as status. 2. No test for membership in or any oaths of loyalty to the Democratic Party in any state should be required or used, which has the effect of requiring prospective or current members of the Democratic Party to acquiesce in, condone, or support discrimination based on status. However, the DNC rules then proceed to require acquiescing to and being subject to discrimination based on status. In Rule 6A, the target of the DNC is laid out. The promises of a democratically elected government, the right to vote, have not always been extended equally to all Americans. Historically, certain groups of Americans have been explicitly denied the right to vote or have been subjected to discriminatory or exclusionary practices with the intended effect of denying them voting rights. In recognition of this past history of discriminatory denial of the franchise and in order to encourage full participation by all Democrats in the delegate selection process and in all party affairs, the national and state Democratic parties, all state Democratic parties shall adopt and implement affirmative action programs with specific goals and timetables, quotas, for the African Americans, Hispanics, Native Americans, Asian Americans, and Pacific Islanders, and women. Put women at the end, but it's the largest one with 51%. They kind of tuck that in at the end as if they're not just using it to take over the government and put in the first woman. This isn't fair. It's a low blow, as Bernie Sanders said. Now, do the rules required for this displace the votes of those supposedly all historically privileged? Yes, as Minnesota shows, this is constitutionally sensitive, treading on the 15th and 19th Amendments and abridging and denying the vote. And in paragraph 3, identical, it is clear, quote, in the selection of each state's at-large delegation. So I guess this is not the special voters, that have the power. There's special superdelegates. Priority of consideration shall be given to African Americans, Hispanics, Native Americans, Asian Americans, Pacific Islanders, and women. If such priority of consideration is needed to fulfill the affirmative action goals outlined in the state's delegate selection plan, such remedial action is necessary in order to overcome the effects of past discrimination. Where are the effects of past discrimination in the Democratic Party against women in Minnesota? There's no evidence in here to justify that. It's a political takeover. Priority of consideration shall also be given to other groups described, which are underrepresented in the Democratic Party affairs, in order to assist in the achievement of full participation by these groups. So if you're not in one of these groups, and women aren't grandfathered in, you're not a priority.